Dear learners, today I will be talking about EIA Laws and Guidelines. This is a part of MEV 001. I am Professor Bhaskar from Guru Jambeshwar University, Hisar, Haryana. After listening to this lecture, you should be able to define EIA, understand the main steps in EIA, understand the EIA guidelines, and appreciate the importance of EIA. Now, environmental impact assessment, by now you must be familiar. The term is that it is of any proposed project to study the negative impact on environment directly or indirectly on a short-term basis or in long run. EIA is to identify the potential positive or negative impacts of the proposed project on environment, that is from a social, cultural, health, biodiversity and aesthetic point of view. Now, if you see, EIA assesses the present condition of the environment where the project is to be executed and what are the possible impacts on the environment due to this project in due course of time. In a nutshell, EIA is anticipatory, it is participatory and it is systematic. Now, what is the background of this EIA? It is one of the most successful environmental policy innovations of the 20th century. This came because of the NEPA Act, National Environmental Policy Act 1969 of the US. And they made this concept of gave this concept of environmental impact assessment and made it necessary for federal agencies to evaluate impact of environmental decisions. Many countries followed the suit in 1970s. USA was the first country to develop EIA after Carlson published the book Silent Spring. The National Environmental Policy Act 1969 of the USA was enforced as legislation for environmental consideration for large-scale project. This was the basis for the development of EIA. The OECD countries' Declaration of Environmental Policy in 1974 was the first international document to incorporate EIA. This declaration was the follow-up of the activities after UN Conference on Human Environment 1972. The Article 9 of this declaration states that it was critical that environmental impact of significant public or private activities be assessed prior to implementation. The history of this is also seen in Earth Summit Rio Conference 1992. The Principle 17 of the Rio Declaration states that EIA as a national instrument shall be undertaken for the proposed activities that are likely to have significant adverse impact on the environment and are subject to the decision of a competent national authority. Again, as per Rio Declaration, EIA refers to both a decision-making process and a document that provides a systematic, accountable evaluation of the potential environmental and socio-economic impacts of a proposed development, activity, action or its practical alternatives. Now, origin of idea, as I said to you earlier, this came from NEPA Act of USA. NEPA Act came into existence in December 1969 and it was signed by President Nixon into a law on January 1st, 1970. The United States NEPA defines EIA as a systematic interdisciplinary approach which will ensure the integrated use of natural and social sciences and the environmental design arts in planning and decision making which may have impact on man's environment. What is the purpose of this act? They did this to have a national policy which will encourage productive and enjoyable harmony between man and his environment, which will promote efforts to prevent or eliminate damage to environment and the biosphere, which will stimulate the health and welfare of man, which will enrich the understanding of the ecological system and natural resources important to the nation, and to establish a council on the environmental quality. In the Indian context, This started after India participated in the Stockholm Conference in 1972 and Rio Summit 1992. India strengthened its environmental governance. India has also been a part to global climate agreements like UNFCCC and Kyoto Protocol, and both of these instruments have emphasized the need for a strong EIA regime to minimize the adverse effects of climate change. Also, the Convention on Biodiversity stresses the need for effective EIA process to safeguard the biological resources. You can see that India participated in these events, and these important events in the environmental history have emphasized the importance of EIA. After participation in Stockholm Conference, Indian environmental jurisprudence saw a new era. Several new legislations came up like the Wildlife Protection Act 72, the Water Act 1974, the Forest Act 1980 and so on. One important addition was the 42nd Amendment to the Constitution that introduced Article 48A and Article 51AG, both of which advocated protection and improvement of the environment. After the Bhopal gas tragedy in 1984, Environmental Protection Act of 1986 under Article 253 of the Constitution was enacted, and it became an umbrella legislation for the environmental protection in India. The EIA regulations in India emanate from this Section 3 of this legislation. Section 3 gives the authority to the Union government to take measures to protect and improve the environment. In India, EIA came informally into existence in 78-79, but it became mandatory only in 1994. The environmental clearance was started in 1978 after EIA study as a directive of Planning Commission, Government of India, done under Department of Science and Technology. In 1980, after the formation of Department of Environment, the job of environmental clearance was transferred to the Department of Environment from the Department of Science and Technology. The environmental clearance and EIA became mandatory in 1994 for selected projects. The Union Ministry of Environment and Forest, Government of India, under the Environmental Protection Act 1986, on 27 January 1994, gave a notification on EIA of development projects. There are a number of amendments in this notification from time to time. What are the main steps involved in EIA? You must have listened to other speakers. They are impact identifications, baseline studies, impact evaluation, assessment, documentation, decision making and post audit. Now, what are the policy and legal framework issues? Adequate provisions for the protection of environment and forest are made in the Constitution of India. As said earlier, Article 47 provides protection for protection and improvement of health. The 48A and 51A, which was introduced, Article 48A is directed towards protection and improvement of environment and protection of forest and wildlife. Article 51A, which is very important, it says that it is the duty of every citizen to protect and improve natural environment. Following this UN conference, Stockholm Conference 1972, these were inserted in the Constitution. Now, EIA notification took place in 1994 and it made environmental clearance mandatory for expansion, modernization and setting up of new projects. Since then, EIA has been amended several times. The most important amendment happened in 2006. Now, EIA notification was notified mandatory EIA under Rule 5 of EPA 1986 for 29 designated projects, after amendment 30 activities. This is the principal piece of legislation governing environmental impact assessment. So, 30 activities were covered under this. The EIA was made mandatory under environmental protection rules with the following objectives: predict the environmental impacts of the project, find ways and means to reduce adverse impact, shape the project to suit local environment, present the predictions and options to decision makers. This was in the mind of the policy makers when this EIA Act 1994 was introduced. Now, the Schedule 2 of the notification expected that the following will be covered: description of the proposed activities, description of the base environmental and climatic conditions and potential affected environment, analysis of land use and land use change, waste generation, water consumption, power consumption along with social and health impacts, description of practical activities as appropriate. It will also cover an assessment of likely or potential environmental impact of the proposed activity and the alternatives, including the direct or indirect, cumulative, short-term and long-term effects. A risk assessment report and disaster management plan to mitigate adverse environmental impacts of proposed activity and assessment of those measures. An indication of the likely area to be affected by the proposed activity or its alternatives. Detailed environmental feasibility report of all the information provided. Now, the amendments, so many amendments came. The first amendment came on 4th May 1994. The amendment occurred again on 10th April 1997, and in this amendment the process of environmental public hearing was introduced in environmental clearance, and this is an important amendment. Now, again amendment took place in 13 June 2002. The pipeline and highway projects are exempted from EIA, but conducting public hearing was mandatory. They made some conditions of the size or the cost of the projects which are excluded. Then again on 28 February 2003, location sensitivity was taken into consideration. Again an amendment occurred in May 2003, and this amendment was to expand the list of activities involving risk or hazard, and these are the river valley projects including hydel power projects or major irrigation projects or their combinations. So, you can see on 4th August 2003 there was again another amendment that every project proposed to be located in a critically polluted area within a radius of 15 kilometers of boundary of reserved forests, ecologically sensitive areas which include national parks, sanctuaries, biosphere reserves, and any state shall require environmental clearance from the central government. Then again on 22nd September there was an amendment, and in which no public hearing was required for offshore exploration activities beyond 10 kilometers from the nearest habitated village boundary. So, you can see so many amendments are taking place depending on the need, and then again on 7th July the amendment took place making EIA mandatory for construction and industrial estates. Again on 4th July 2005, we had an amendment that related to expansion or modernization of nuclear power and related projects like ports, harbors, airports, etc. And they require, if it is less than 5 hectares, then they could be taken up without prior environmental clearance. Again, the EIA notification took place in 2006. It was an outcome of the recommendations made by Govindarajan Committee. It was constituted to examine the procedures for investment approvals and project implementation. It was found that government clearances causes maximum delay to projects and recommend some of the cumbersome procedures be modified. Consultations on draft notification was held only with representatives from industry and central government agencies. Now, this notification tried to bring a number of projects within its purview of environmental clearance process. As a result, a revised list of projects and activities has been redrawn that requires prior environmental clearance. Most importantly, there is no categorization of projects requiring EIA based on investment. Rather, size or capacity of the project determines whether it is cleared by central or state government. Now, the major difference of the EIA notification from the earlier 1994 notification is it attempts to decentralize power to the state government. Earlier, all projects under Schedule 1 went to the central government for environmental clearance. However, as per 2006 notification, significant number of projects will go to the state for clearance depending on its size, capacity and area. For this, notification has made a provision to form an expert panel, the environmental appraisal committees at the state level. So basically, decentralization was promoted in this. Then there were certain amendments requiring the exemption of industrial shed for the requirement of environmental clearance, and the word industrial shed implies building which is being used for housing plant and machinery of industrial units, and this has been exempted. Now, list of projects requiring environmental clearance from central government. There are 30, I said to you, broadly: nuclear power projects, river projects, ports, petroleum refineries, chemical fertilizers, pesticides, petrochemical complexes, pharmaceuticals, exploration of oil and gas, synthetic rubber, asbestos. You can see metallurgical industries, storage batteries, tourism, thermal power plants, mining projects, highway projects, distilleries, pulp, paper. You can see the list. There are around 30 requiring. Now, there is a latest notification, draft EIA notification 2020, and this government has put up this. As per government view, the EIA notification has been amended nearly 55 times and 230 office memorandums have been issued, which created a lot of confusion. The government feels the purpose of the present draft is to compile and systematize these changes to avoid confusion. But what are the key issues in this draft EIA notification 2020? It allows post facto clearance for many projects. That means project can be started and later submission for EIA. Strategic projects are exempted from clearance. That means no information will be available in the public domain. Government can classify any project as strategic. Inland waterways and national highways excluded from public consultation. Construction projects exempt from EIA if it is less than 1,50,000 square kilometers. Violations can be reported by government representatives or project proponent and not citizens. More importantly, the current 30 days to 20 days, it has been reduced to 20 days for public consultation. Now, importance of EIA, if you see international, besides framework and convention, the International Court of Justice has acknowledged the importance of EIA. In the pulp mills on River Uruguay judgment, the ICJ recognized the environmental impact as an obligation of the general environmental law. Then you can see the Indian context. It is not that the Indian courts have not commented. In the case of Alembic Pharmaceuticals versus Rohit Prajapati, the Supreme Court condemned the ex post facto environmental clearance, and it stated the concept of an ex post facto environmental clearance is in derogation of the fundamental principles of environmental jurisprudence and is an anathema to the EIA notification dated 27th January 1994. It is, as the judgment in common cause holds, detrimental and could lead to irreparable degradation. So, even courts have said ex post facto environmental clearance is not a good concept. Now, again you can see in the Honorable Supreme Court case of Association of Environmental Protection versus State of Kerala, held that commencement of project without obtaining environmental clearance is a violation of the fundamental right to life guaranteed under Article 21 of the Constitution. This is a very, very important linkage with fundamental right to life. That means environmental clearance should not be given without doing the EIA. Again, in case of Supreme Court case of Lafarge Mining Private Limited versus Union of India, it was held that public consultation was mandatory requirement of environmental clearance for an effective forum for a person aggrieved by any aspect of any project to register and seek redressal of their grievance. That means public hearing was an important aspect. Again, in the Samarth Trust case, the Delhi High Court highlighted the importance of public hearing, stating that A public hearing is a form of participatory justice, giving voice to the voiceless, and a place and occasion to them for them to express their views with regard to a project. Such public hearing gives an opportunity to the people to raise issues pertaining to the social impact and health impact of the proposed project. In another case, in Mazdoor Kisan Ekta Sangathan versus Union of India, the Supreme Court declared faulty public hearings to be nullity in the eyes of law. So you can see, even in the international context, even the ICJ in the case of Costa Rica versus Nicaragua highlighted the importance of public participation and EIA process as a whole, saying that it was an exemplary process to follow. So we have seen both at the national and international level, the EIA, the public participation has given due importance. And what are the conclusions? Therefore, the endeavor for the union government now must to be to draft an EIA that takes into account the interest of all stakeholders and gives top priority to environmental concerns. It should also keep in mind conformance to existing conventions, laws, precedents and environmental jurisprudence of the country. After listening to this unit, listeners, you should be able to define EIA and understand its origin, understand the main steps in EIA and appreciate the importance of EIA for environmental protection. Thank you very much for patient listening.